Attention students, I congratulate all of you that you have managed to come to this class, which is the final year class on my course, the legal practice class. I am Advocate Soboni, and I'm going to be your mentor throughout the year, and I hope that we will have a productive year. You are under pressure because the students that I had in 2022 were very diligent. There's been talk about your character, that you are lazy students, that you are not cooperative, you want to be pushed, and yet we are here preparing you to be professionals. First of all, I am going to warn you that if you can't be a fit and proper person, I would advise that you change the course, go to another discipline, because law demands that you must be fit and proper. Fit and proper is a very difficult concept to master, because even if you make women pregnant and leave them with kids that are uncared for, if that woman can come back and oppose your application in Pietermaritzburg, you can be deemed not to be fit and proper. So you need to be careful. If you are too friendly with the SRC, you are seen being the one that runs in the front with banners, jumping and banning the university infrastructure or property. You are not a fit and proper person. So you are in a wrong profession. People who jump around with bottles, Molotov, what we call Molotovs, or these petrol bomb cocktails, cannot be lawyers, because what is going to happen is that after everything else is done, you've done your so many years of study, and you've done your articles, you have written your board exam, and you've made your application now to be admitted, you will still have to come to us to ask for a testimonial. And if we look at the videos in the university when there were strikes and we see you in front jumping with cocktail Molotov of petrol bombs, obviously we are not going to give you a good testimony about you. So you need to be careful. If you are trying to be a hero, a student hero, and you want to be a student leader and hero and destroy university property and be arrogant and do not want to cooperate, then you are not fit to be a lawyer. I would advise you to change, or don't even waste your time. Go and look for work as a legal advisor or anything else from the government departments or in the private sector, because you are not a lawyer. You are not fit and proper. I hope everybody understands. So let us begin with our class. Okay, students, let us start with an animal called case citation. We are dealing with criminal procedure in this semester. We will be dealing with civil procedure in the next semester. So for now, it's going to be civil procedure. What you do when you go to court, how do you apply for bail, how do you do applications in court for bail, and how do you conduct a trial, how do you present a case if you are a prosecutor, because we'll also train you to be prosecutors, because I tell you, last year in 2022, we had so many students that were employed by the NPA. And I want the same thing to happen with you this year. So we are going to stick on criminal procedure. All right, let us talk of something called case citation. Case citations means when you support your argument, then you will have a case law that is prepared. You go and read a case that has the same objective as the case in hand, which means you use what is called a precedent. The precedent is decided cases, stare decisions. You've heard of stare decisions, decided cases. We will be using those to support your argument. So if you are arguing, for instance, against a matter where somebody is to be given a death sentence, which case you will be using? You will be using this case of State versus Mankwanyana, all right? To say the tradition of hanging people was stopped in the case of State versus Mankwanyana. So you can use that to support your argument. So if any judge says, oh, we are going to hang this guy, you will use that case to say, no, you can't hang him because there's a decided case that said hanging people in South Africa is unconstitutional because of that constitutional imperative that is right to life. Okay, so now we are talking about, now you know what do I mean by case citation. So you will cite that case. You say State versus Mankwanyana, or you just say in Mankwanyana case, or in Joubert case, or in Stellenbosch case, or in Zuma case, right? So you will use that. And then if you are citing a case, you must state whether that case was in the constitutional court or was in the appeal, court of appeal, that is now Supreme Court of Appeal, that is now SCA. If you see the letters SCA, that is Supreme Court of Appeal in Bloemfontein. If you see CC in brackets, that is now the Constitutional Court. So you will quote that. So in all the time when you are citing a case, always use a Supreme Court of Appeal case or a Constitutional Court, because those cases have more power than a decided case in the South Gauteng case or in the Durban High Court. You see, you will use a case where there was an appeal against a decision, and that case or that appeal succeeded. Then you can use those, because those have precedent, and judges are inclined to follow the same decision, right? So you will do that, right? There's also something called referencing of legislation and specific abbreviations used. Now, when you are dealing with legislation, there's a legislation called the Criminal Procedure Act 51 of 1977. Now, how do you abbreviate that? How do you reference that? You'll say in terms of the CPA. So you'll use the letters CPA, all right? And then you use the CPA. If you want to quote the Child Justice Act, you will use the letters in terms of the CJA, that is the Child Justice Act. This is how you abbreviate. If you want to use the same thing will apply with the Mental Health Act. So you'll say in terms of the MHC, which is the Mental Health Care Act, right? So it's MHCA, right? Of 2002 is Act number 71 of 2002. So you can refer to those legislations. I've said the CPA, the Mental Care Act, the Child Justice Act. Child Justice Act will be Act 75 of 2008, and also the Mental Health Care Act will be Act 17 of 2002, right? And it's just referred to as Mental Health Care Act. even in Afrikaans and in English, you use the same thing. But now let's not deal with Afrikaans because it's not most of the time that you will have to present your case in Afrikaans, right? There's also another legislation which is very important, the Constitution. When you want to drive your point home and you don't want anybody to doubt your argument, always use the Constitution, because the Constitution governs everything. If you say whatever has been done is unconstitutional, for instance, we were talking last year, we were talking of Mr. Fraser got the footage of dollars in the president's Phala Phala farm in a cushion or a mattress, I'm not sure. Now, you can see that that information was obtained illegally. So if you are the advisor of the president, you will then say, Mr. President, don't answer this, because this whole fiasco about Phala Phala farm has been derived from information that was obtained illegally, because there was no order of the court or a search warrant or a document such as a court order that said somebody must go and tape or take pictures of dollars in the farm of the president. So that information was obtained illegally, and the Constitution doesn't allow that. You cannot never convict a person or find anybody guilty with information that was obtained unconstitutionally. So the Constitution of the Republic will be regarded as the Constitution. It is the Act, I think it's Act 108 of 1996, right? So that Act, you refer to it as the Constitution. And also, there is another Act which is relevant for the purposes of our study. That is now the Director of Public Prosecutions Act, right? That also is very important. You need to know it, right? And also the Director of Public Prosecutions, the National Prosecutions Act, it's not that, it's the National Prosecutions Act. It's also very important. You need to know those acts. And also the Director of Public Prosecution will be referred to as the DPP. That is the Director of Public Prosecutions. So you need to take note of those and make sure that students, to continue, right, we were dealing with these legislations, very important legislation when it comes to criminal procedure, right? And you must know there are general procedural principles that need to be followed when you are dealing with the criminal procedure, right? The most important acts that you need to read for the purposes of this course are Section 144, subsection 3, and Section 153, subsection 2, and Section 170, capital A of the Criminal Procedure Act. You need to read those for the purposes of procedures that to be followed in when dealing with criminal procedure. Also, what is important is the section that deals with arrested and detained persons. That will be Section 35 of the Constitution. So you look at Section 35(1), Section 35, subsection 2, subsection 3, subsection 5 of the Constitution. Remember, we said the Constitution is Act 108 of 1996. So you need to look at those so that you don't commit irregularities when dealing with arrested persons. Also, you must also look at the Magistrate Court Act 32 of 1944, and I've spoken about the National Non-National Prosecuting Authority Act, right, of 32 of 1998. So you must also look at that. This National Prosecuting Authority Act 32 of 1998. And also there's another one which is very important. The Witness Protection Act is Act 112 of 1998. So when you are a prosecutor, you must also consider that your witnesses, you invoke this act in order to make sure that your witnesses are not killed. Because if you don't protect your witnesses, they are going to be attacked by the accused and be killed, right? So if you want to deal with those, there are cases that you can refer to. There's another one is Motlotsi. Motlotsi will be MOTLOUTSI, 1996, volume 1, SACR. You must know what do we mean by SACR, right? 78, C in brackets, and also the 1996. Another one is 1996. Same case, Motlotsi case, 1996, volume 2, BCLR. Also, you need to know what do we mean by BCLR. If you don't know, you come to me in class and I will explain to you. So, but you can do your research, go to Google or go to Safli and find out what is meant by SACR, but it says itself, and then BCLR, something to do with Butterworth, right? Criminal law reports, something like that. But if I tell you something in class, you don't just say advocate said BCLR is Butterworth criminal law reports. You must go and find out and confirm. Maybe what I'm saying is not so correct, it is a mistake, but go and confirm it. Come back and say, advocate, you were right. BCLR stands for Butterworth criminal law reports, right? It's 220 C. That will be the seat of the court, right? Also, another case that we must look at is Feldman. Feldman is VELDMAN. Feldman versus Director of Public Prosecutions, Witwatersrand Local Division, 2006, Volume 2, SACR, the South African Crime Reports, Criminal Law Reports, 319 CC. So I said CC stands for Constitutional Court. So this is a very strong case because it's a constitutional matter. So it takes precedent. If you invoke that to support your argument, obviously the judge or the magistrate is going to agree with you. Another one is 2007, volume 3, SA, at page 210. Another one is 2007, volume 9, BCLR, at page 929. And also you look at 2005, ZACC 22. That's the case number. South African Constitutional Court. ZACC stands for that. It's a constitutional court matter. Same court, Veldman versus Director of Public Prosecution. So you look at those cases. They are very important to support your argument, right? So in our class, we are going to be teaching in this way. We are going to be dealing with possible questions because I want everyone to pass in my class. So what do? I teach the questions. I don't teach theory. I teach the questions. So a scenario will say, the question will be say, every country needs rules, principles, mechanisms, and state organs to prevent, identify, control, and investigate criminal behavior, right? In the light of the above statement or assertion, briefly discuss the importance of criminal procedure in the legislative process. That's a question for a final year student. And we're going to discuss it and also discuss how to answer that question. But first of all, you need to understand. You need to understand what do we mean by that question, right? And the answer to that will be simple. Here's the answer. The purposes served by criminal procedure are as follows. One, criminal procedure provides a process that vindicates substantive criminal law goals. Procedural mechanism must therefore determine substantive guilt reliably, authoritatively, and in a manner that promotes the criminal law sentencing objective. That is the answer to the above questions. Secondly, criminal procedure provides a dispute resolution mechanism. So this is a dispute resolution mechanism. When you take somebody to court, you are going to court and you are saying this person has committed criminal injury. This person has insulted me. Then we go to court and then we find a solution to your problem. So criminal procedure provides a dispute resolution mechanism that allocates scarce resources efficiently and that distributes power among state officials. But now the problem with the criminal procedure is that you get punished. But sometimes there's something called ADR. You will hear of ADR when you come to court. This is ADR stands for Alternative Dispute Resolutions. If somebody beats you up and you go to a doctor and you spend 10,000 Rand in expenses, hiring a car to take you to hospital because there are no ambulances, and you go there, you pay for your medications and you pay for doctor's fees, and you go there about 10 times, then you open a case against somebody. You can then say, okay, let's do something called ADR. Pay me for all my expenses and then I will drop the charges against you, because if you go to jail, what am I going to get? I'm not going to get anything, but the state is going to incur expenses in that it has to feed you 3 times a day or provide a bathing for you, soap, blankets, bedding, and shelter. And that costs for one prisoner. For one prisoner a day, the state pays 2,500 Rand a day. So you can imagine we've got about how many prisoners in South Africa? Quite a lot. It's quite a lot. So it's about 100 and something thousand prisoners in our prisons. So the state is losing a lot of money by keeping this. So if we can find a way, easy way out, because this, like I'm saying, the scarce resources must be used efficiently, right? And but people should be protected. Also, state-citizen disputes can be resolved in a manner which commands the community's respect for the fairness of process and the reliability of the outcome. So the citizens must trust the system, that it works for everyone. It works with no fear or favor. So that's what we understand about these first questions, right? So all of the above are subject to the supremacy of the Constitution of the Republic of South Africa. So the Constitution of the Republic of South Africa is the supreme law, and each and every law should comply with the directives of the Constitution. So, like I'm saying, we are going to be doing what? We are going to be probing questions. This is how we are going to learn in our class for legal practice. We are going to be probing questions, give you questions, and we try and answer those questions. This is how, and our exams will come from those questions.